opportunity to explain the procedure that will be followed in the event of questions being put by members of the court to participants in these proceedings. Such questions will be asked at the close of the hearings on the afternoon of Friday, 2nd May 2025, after the last delegation has completed its presentation. The written text of such questions will be transmitted to the participants by the registrar. Written replies should be provided by Wednesday, 7 May 2025 at 6 p.m. No written comments on these replies are envisaged. I now give the floor to the United Nations, and I invite Ms. Elinor Hammarskjöld, Legal Counsel of the United Nations, to the podium. Madam, you have the floor.
Thank you, Mr. President. Mr. President, members of the Court, it's a great honour for me to appear in front of you on behalf of the Secretary General of the United Nations in the context of this request for an advisory opinion. At the outset, I want to underline that the Secretary General is making every effort to alleviate and bring to an end the ongoing and persistent human suffering of the population in Israel and the occupied Palestinian territory, including the hostages and their families, and all those affected by the ongoing armed conflict. There is an urgent need to return to a ceasefire and for the parties to respect their obligations under international law. The Secretary General has consistently reiterated his strong and unequivocal condemnation of the abhorrent acts of terror by Hamas and other Palestinian armed groups on 7 October 2023. He has also repeatedly called for all the hostages to be released immediately and unconditionally. No humanitarian aid or commercial goods have been allowed into Gaza since the 2nd of March, which has devastating humanitarian consequences in the Gaza Strip. The Secretary General continues to call for humanitarian aid to reach all people in need. As I stand before you, 295 United Nations personnel have died in Gaza since the 7th of October 2023. Mr. President, the request in General Assembly Resolution 79232 that the Court render an advisory opinion focuses on the obligations of the State of Israel. This statement will therefore do likewise. Before doing so, I want to reiterate that all parties to a conflict must comply with all their obligations under international law, including international humanitarian law and international human rights law at all times. In the context of the situation in Israel and the occupied Palestinian territory, Israel, the State of Palestine, and non-state actors, including Palestinian armed groups such as Hamas, have obligations under international law that must be observed.
Mr. President, members of the Court, the purpose of this oral statement is to assist the Court in the present advisory proceedings concerning the obligations of Israel as occupying power and member of the United Nations, with regard to the presence and activities of the United Nations in connection with the occupied Palestinian territory. The United Nations has a special and direct interest in these proceedings. Detailed information has already been provided in the written statement on the presence and activities of the 13 United Nations entities in the occupied Palestinian territory. So I will not repeat that information today. I shall confine myself to pointing out that all these entities are subsidiary organs of the United Nations within the meaning of the Charter, or form part of the United Nations Secretariat. In this respect, I would stress that the status of these entities is irrefutable. These entities are engaged in the unhindered supply of basic necessities essential to the survival of the Palestinian civilian population. Also, in some cases, these entities are engaged in the provision of basic services and humanitarian and development assistance in the interest of the Palestinian civilian population and in support of the right of the Palestinian population to self-determination. Today, I will present my remarks as follows. First, I will refer to Israel's obligations as the occupying power. And second, I will refer to Israel's obligations as a member of the United Nations.
Members of the Court, I will now elaborate on the obligations of Israel as an occupying power. After making initial preliminary remarks, I will turn to three specific issues. First, the scope of relief schemes under the Fourth Geneva Convention. Second, the limitations on the authority of the occupying power to administer an occupied territory. And third, the protection of humanitarian, medical, and United Nations personnel in general. Israel has several obligations in relation to the presence and activities of the United Nations in the occupied Palestinian territory by virtue of its status as the occupying power. These obligations include the following obligations under international humanitarian law: the overarching obligation to administer the territory for the benefit of the local population, the obligation to agree to and facilitate relief schemes, the obligation to facilitate the proper working of all institutions devoted to the care and education of children, and the obligation to maintain the medical and hospital establishments and services, including those set up by United Nations entities. In the specific context of the current situation in the occupied Palestinian territory, these obligations entail allowing and facilitating all relevant United Nations entities to carry out those activities for the benefit of the local population. In addition to international humanitarian law obligations, international human rights law obligations are also applicable to the conduct of Israel with regard to the occupied Palestinian territory. This includes respecting the decisions of the representative of the Palestinian people to receive basic goods and services from the United Nations entities in order to fully enjoy their right to self-determination. Israel is bound to respect the decision of the Palestinian people on the manner in which the dependence of the West Bank, including East Jerusalem and Gaza, on Israel for the provision of basic goods and services should be reduced. Israel has the obligation to render assistance to such activities of the United Nations. Mr. President, members of the Court, against this background of an overarching framework, I would like now to move specifically address 3 points of international humanitarian law. First, I would like to address the scope of relief schemes under Article 59 of the Fourth Geneva Convention. I recall that under Article 59, the occupying power is required to agree to relief schemes and facilitate them if the whole or part of the population of an occupied territory is inadequately supplied. Article 59 refers to relief schemes in general. The plain terms of Article 59 do not limit relief schemes to objects that are urgently needed for the survival of the civilian population. Article 59, paragraph 2, specifically refers to foodstuffs, medical supplies, and clothing. These are examples of relief supplies and do not constitute an exhaustive list of objects that constitute relief schemes. The content of relief schemes depends on the needs of the population of an occupied territory. The legal obligation covers those needs that have to be addressed immediately. For example, when a large number of population is displaced due to military operations, relief schemes would comprise items that are essential to address their immediate needs, such as food, water, shelter, and hygiene facilities. The definition should also be understood to cover needs which may be more long-term, in particular in cases of prolonged occupation. For example, relief schemes to address long-term needs may include items that are essential for the construction and repair of certain infrastructures, including medical and sanitation facilities, and items and services to eradicate poverty. Therefore, the needs of the population in an occupied territory could evolve depending on the nature and duration of the occupation, and relief schemes need to be adapted to the evolving needs. The occupying power must agree to such relief schemes as adapted and facilitate them. Second, the authority of the occupying power to administer an occupied territory must be exercised in a manner that is consistent with international humanitarian law. Any measures taken by the occupying power to ensure its security must be exercised in a manner that would not deny impartial humanitarian organizations, such as the United Nations, the ability to carry out relief schemes, while part of the population of an occupied territory continues to be inadequately supplied. In instances where the occupying power has concerns with the impartiality of a humanitarian organization, the occupying power may not unilaterally declare that such humanitarian organization is not impartial and deny its relief schemes. Such concerns must be addressed in consultation with the humanitarian organization concerned. I will elaborate on this point later. Third, under international law, including international humanitarian law, humanitarian relief personnel, medical personnel, and United Nations personnel must be respected and protected. As such, attacks may not be directed against such personnel as long as they are entitled to the protection given to civilians under international humanitarian law. At every stage of the conduct of military operations, all feasible precautions must be taken to avoid, and in any event to minimize, incidental casualties to humanitarian, medical, and United Nations personnel. They must be treated humanely and must not be subjected to harassment or intimidation. They are also protected by international human rights law. As such, they must not be subjected to arbitrary arrest or detention. United Nations personnel, including those who carry out humanitarian and medical work for the United Nations, are also accorded particular status under the Charter of the United Nations and the Convention on the Privileges and Immunities of the United Nations, to which Israel is a party. Consistently with their status as United Nations officials or experts, United Nations personnel may not be attacked, arrested or detained, or subjected to any form of legal process in connection with their official functions. Privileges and immunities are granted to United Nations personnel in the interests of the organization. Interference with their functions impedes the activities of the United Nations as an organization. Mr. President, members of the Court, I will now move on to the second part of my statement, which concerns Israel's obligations as a member of the United Nations. I will start by recalling the unlawfulness of Israel's continued presence in the occupied Palestinian territory and the relevance of this to the present proceedings. I will then recall the general obligations arising from the Charter and the 1946 Convention on the Privileges and Immunities of the United Nations, which I shall refer to in my statement as the General Convention. I will then specifically discuss, first, the inviolability of United Nations premises, second, the general obligation of cooperation with the United Nations, and third, the issue of impartiality of certain United Nations entities. Mr. President, members of the Court, I will now turn to the first point, the unlawfulness of Israel's continued presence in the occupied Palestinian territory and the relevance of this to the present proceedings. Under international law, states, including members of the United Nations, are prohibited from acquiring territory by force. In the advisory opinion of 19 July 2024, this court concluded that Israel's assertion of sovereignty over and its annexation of certain parts of the occupied Palestinian territory constitute a violation of the prohibition of the acquisition of territory by force. On this basis, the court has authoritatively determined that Israel is not entitled to sovereignty over or to exercise sovereign powers in any part of the occupied Palestinian territory on account of its occupation. The enactment of the law to cease Unrwa operations and of the law to cease Unrwa operations in the territory of the State of Israel by the Knesset of Israel on 28 October 2024 appears to constitute an extension of sovereignty over or exercise sovereign powers in the occupied Palestinian territory, including East Jerusalem. The same can be stated regarding any measures taken on the basis of those laws and other applicable Israeli law in the occupied Palestinian territory, including East Jerusalem. They are, as such, inconsistent with Israel's obligation under international law. Insofar as the law to cease UNRWA operations in the territory of the State of Israel, among other effects, prevents UNRWA operations in East Jerusalem, which Israel considers to be part of the territory of the State of Israel, the enactment and implementation of this law is also inconsistent with the international legal status of East Jerusalem. I will now turn to certain general obligations under the Charter. The present proceedings are crucial because they will afford the opportunity to clarify certain fundamental elements of the legal framework applicable to the United Nations. The status of Israel as a member of the United Nations entails several legal obligations concerning the presence and activities of the United Nations in and in relation to the occupied Palestinian territory. These obligations are all essential for the organization to properly function and perform the mandates it has been entrusted by its member states. The exclusively international character of these functions and mandates is enshrined in Article 100 of the Charter. When the basic elements of this legal framework are not observed, the very nature of the work of the organization on behalf of its member states is in jeopardy. The basic elements of the legal framework of the United Nations include general principles of good faith and cooperation with the organization, obligations concerning the safety and security of United Nations premises, property, assets, and personnel, and more specifically, obligations concerning the privileges and immunities of the United Nations and its premises, property, assets, and personnel. Regarding these, I wish to note that the Charter confers certain privileges and immunities to the organization so that it may fulfill its purposes, as Article 105 of the Charter makes clear. Such privileges and immunities are applicable to all entities that are integral to the United Nations, including its subsidiary organs such as UNRWA, which was established by the General Assembly as its subsidiary organ. In the written statement of the Secretary-General, the obligations stemming from the Charter and from the General Convention were elaborated in detail. These principles are well set in law and practice. In this regard, I welcome the fact that a clear majority of member states, having submitted written statements, appear to agree on the importance of the privileges and immunities of the organization and its personnel. Today, I wish to underline, before turning to certain specific points, the importance for United Nations operations of the obligation to uphold the immunity from legal process of the United Nations and its personnel, irrespective of which United Nations entity they may be assigned to. Equally important is the obligation to facilitate the movement of supplies, goods, and equipment of the United Nations and the freedom of movement of its personnel. Particularly since the end of January this year, United Nations operations on the ground, specifically for UNRWA, have faced increasingly difficult conditions. Following the enactment and implementation of the Knesset laws, the issuance of visas to UN personnel has been further denied or restricted, and actions have been taken against UNRWA personnel in connection with their duties for the organization. There has been unauthorized entry into UNRWA schools, and orders for their closure have been issued, notwithstanding the ongoing mandate for UNRWA activities. In this regard, it is necessary to uphold the privileges and immunities of the United Nations and its personnel. As set out in documents contained in the dossier provided to the court, violations of these obligations have occurred. Differences arising out of the interpretation or application of the General Convention may result in a situation in which a difference under the General Convention has arisen between the United Nations and Israel. Mr. President, members of the court, I would like now to elaborate more specifically on 3 points. First, I wish to emphasize the absolute and mandatory obligation to respect the inviolability of United Nations premises, property, and assets at all times, including during armed conflict, in accordance with international law. Article 2, Section 3 of the General Convention provides that the premises of the United Nations shall be inviolable. Also, that property and assets of the United Nations, wherever located and by whomsoever held, shall be immune from search, requisition, confiscation, expropriation, and any other form of interference, whether by executive, administrative, judicial, or legislative action. Consistently with this provision, inviolability entails that state agents may not enter or otherwise physically penetrate or physically interfere with the United Nations premises without the prior consents of the United Nations. It also entails a duty on the part of the state to take all appropriate measures to prevent the United Nations premises being entered or otherwise physically penetrated, damaged, or interfered with by other actors. State officials, including members of the armed forces and domestic law enforcement authorities, may not enter United Nations premises without authorization by the United Nations. Any other form of interference is also prohibited by Article 2, Section 3 of the General Convention. These obligations, therefore, also prohibit any state authorities, including a state's armed forces or security forces, from hitting, damaging, or attacking United Nations premises, property, and assets. There are no stated qualifications to or limitations on inviolability in the General Convention and other relevant agreements. There is no reference to inviolability being merely functional in nature, as is in the case for certain other provisions in the General Convention. Nor is there any reference in the General Convention to situations of armed conflict, civil unrest, or other emergency situations as constituting possible limitations on such inviolability. The respect for the inviolability of United Nations premises, property, and assets is an indispensable precondition for the organization to be able to implement its mandated activities all over the world, including in the occupied Palestinian territory. Serious breaches of international law have been committed by parties to the ongoing conflict, but a breach by one party does not excuse breaches by other parties. I will now refer to the second point, the general principles that enshrine obligations of cooperation with the United Nations. It is from the preamble of the Charter that we derive the notion that member states have committed to combining their efforts to accomplish the aims of the organization. Among the principles set out in Article 2 of the Charter is that all members, in order to ensure to all of them the rights and benefits resulting from membership, shall fulfill in good faith the obligations assumed by them in accordance with the present Charter. Another of the principles is set out in Article 2, Paragraph 5 of the Charter, which requires in its first part that all members shall give the United Nations every assistance in every action it takes in accordance with the present Charter. Consistently with the Court's interpretation of Article 2, Paragraph 5 of the Charter in its advisory opinion concerning reparation for injuries suffered in the service of the United Nations, in the practice of the Secretariat, Article 2, Paragraph 5 of the Charter has generally been interpreted as meaning that member states are required to provide every assistance to the United Nations entities to ensure the effective implementation of their mandates. In this context, it has been generally relied upon when calling upon states to comply with their obligations under Article 105 of the Charter and the General Convention. In the present case, the United Nations action consists of the activities carried out by a number of United Nations entities in the occupied Palestinian territory. Such activities are carried out consistent with resolutions of the Security Council and the General Assembly, and with mandates provided by various United Nations bodies, in a context in which this court has authoritatively held that Israel is not entitled to sovereignty or to exercise sovereign powers. In these circumstances, Article 2, Paragraph 5 of the Charter is directly relevant in the context of Israel's responsibilities vis-à-vis the presence and activities of the United Nations in and in relation to the occupied Palestinian territory, in accordance with international law, including other provisions of the Charter. Finally, my third point, referred to in certain written submissions, relates to allegations that have been raised as to the impartiality of certain United Nations entities. The United Nations considers very seriously any credible allegations against the organization, including those involving its personnel or misuse of its premises. Any such concerns must be brought to the attention of the organization so that the matter may be considered by the United Nations in accordance with its legal framework, including the privileges and immunities of the organizations and its personnel. The organisation has established a framework to address and investigate specific allegations of incidents brought to its attention, which is in line with the status, privileges and immunities of the UN. With regard to allegations against United Nations personnel, the regulatory frameworks of the United Nations require such allegation to be confirmed through an internal administrative investigation, which may include referring the allegations to the Office of Internal Oversight Services, OIOS, for investigation. The ability of the United Nations to further inquire into allegations depends on the full cooperation of member states, including the provision of relevant documents and materials, without which the organisation may not have sufficient basis to take further action in specific cases. Where concerns relate to broader issues, the organisation has taken further steps to review the matter. For example, following allegations that have been raised against UNRWA and its personnel, UNRWA and OIOS have taken steps to investigate those allegations in line with the organisation's regulatory framework and continue to do so. In response to Israel's concerns regarding the neutrality of UNRWA personnel more broadly, the Secretary-General appointed the former Foreign Minister of France, Catherine Colonna, to lead an independent review to assess whether UNRWA was doing everything within its power to ensure neutrality and respond to allegations of serious neutrality breaches when they are made. The Secretary-General and UNRWA have expressed their commitment to fully implementing the review's recommendations with the support of member states. We note that such steps have been welcomed by the General Assembly and by a number of member states in their written submissions for these proceedings.
Mr. President, members of the court, I conclude by recalling that Israel continues to launch devastating strikes on Gaza, strikes that have continued to claim the lives of hundreds of civilians, including United Nations personnel. Furthermore, no humanitarian assistance has been allowed into the Gaza Strip since early March. As a result, the Secretary-General has taken the difficult decision to reduce the organization's presence in the Gaza Strip, even as humanitarian needs are increasing dramatically and our concern for the protection of civilians is growing. The United Nations is determined to carry out its mandates in the occupied Palestinian territory, including Gaza, in particular by providing civilians with the assistance they need to ensure their survival. In order for United Nations entities carry out their functions, all parties to the conflict must fully respect their obligations under international law, including the obligation to protect the absolute inviolability of United Nations premises and the obligation to ensure respect for the independence and status of United Nations personnel. In this regard, Israel's compliance with its obligations under international law is essential for the United Nations entities to carry out their mandates in and in relation to the occupied Palestinian territory. Such respect for international law is equally essential for the protection of civilians, and so that our colleagues at the United Nations can continue to work to save civilian lives without facing intolerable risks. Respect for international law by all parties remains the only option for lasting peace, as well as for the security and justice of Israelis and Palestinians. Mr. President, members of the court, thank you for your attention.
I thank Ms. Elnor Hamsholt. I now invite the next participating delegation, Palestine, to address the court. And I call His Excellency Ambassador Amal Hijazi to the podium. You have the floor, Excellency.
Mr. President, members of the court, it's an honor for me to present Palestine today and its proud people in these proceedings at a time of existential crisis for the Palestinian people. and for the rule of international law. On behalf of Palestine's delegation, I wish to congratulate you, Mr. President, on your election as President of the Court and to wish you success in your tenure. Allow me also to express our gratitude to the courts holding these hearings on an expedited basis. As I address you today, the Palestinian people are being starved, bombed, and forcibly displaced by Israel, their unlawful occupier. Israel has not allowed food, water, medicine, and medical supplies or fuel into Gaza for the past 2 months, a policy supported by the highest court in Israel, which rejected petitions to allow aid into Gaza on several occasions. This man-made catastrophe of unprecedented because the General Assembly asked the court to determine the legal obligations of Israel in relation to the provision of urgently needed humanitarian assistance by the United Nations, other international organizations, and third states, and in relation to the exercise of the right of Palestinian people to self-determination. This request was provoked by the international community's outrage at Israel's methodical targeting, banning, and obstructing of said parties, including its legislation banning the United Nations Relief and Works Agency of Palestine Refugees, Unrwa, from fulfilling its UN mandate in the occupied Palestinian territory, including East Jerusalem. There can be no doubt about the court's jurisdiction in these proceedings. The question raised by the General Assembly is plainly a legal one. It specifically asks the court to advise on Israel's legal obligations under international law and other rules of international law. Nor is there any reason, let alone a compelling one, for the court to decline to answer it, as the court has already determined in 2 prior advisory opinions. The question of Palestine is fundamental to the United Nations and its mandate in this case. This request was provoked by the international communities. During this presentation, the State of Palestine will present evidence on the devastating immediate, intermediate, and long-term consequences of this unlawful Israeli policy on Palestine and its people, on every aspect of their fundamental rights and continued existence. The State of Palestine will also present the court how Israel's prohibited conduct extends to the occupied West Bank, including East Jerusalem, because the target of these actions, by admission of top Israeli leaders, is the permanent annexation of the Palestinian territory and the ethnic cleansing of Palestinians. It is a self-incriminating admission that debunks the security sham they used to justify their genocide, as we will also demonstrate in our presentation. Mr. President, members of the court, before I go any further, allow me to first address the context in which these deliberations are happening. This legal and moral crisis is not 18 months old. Israel has been systematically dispossessing, uprooting, slaughtering and imprisoning Palestinians in absolute flagrant disregard for international law and the inalienable rights of the Palestinian people for 8 years now. It has done so with the intent to destroy our people and to thwart the realization of self-determination in their homeland. To implement this policy, Israel has waged a relentless campaign of erasure against Palestinian people, their demography, their material presence, their national identity, their history and heritage, and their very humanity. This campaign of erasure was a central hallmark of the Nakba that started in 1947, and whose darkest chapter yet, unfolding before our eyes and yours. On 3 separate occasions in the past years, the court issued provisional measures ordering Israel, among other things, to ensure and facilitate the unimpeded flow of humanitarian assistance into Gaza. Israel did not comply. On 19 July 2024, this court also ruled that Israel's presence in and control over the occupied Palestinian territory is unlawful and must come to an end. The court also ruled that despite the illegality of occupation regime, Israel was still bound by its obligations under international law as an occupying power. These obligations include ensuring the welfare of the protected civilians. Israel defied this ruling and the rule of law, brazenly declaring instead its official policy of annexing the occupied Palestinian territory, forcibly displacing Palestinian people, weaponizing food and humanitarian aid, and negating refugee issue and their rights, including by banning Unrwa. On 21st of November 2024, the ICC issued arrest warrants for the Prime Minister of Israel and now his former Minister of War, in part because they intentionally deprived civilian population in Gaza of food, water, medicine, and other essentials. To summarize, Israel is an unlawful occupying power, standing trial for genocide. Its Prime Minister is wanted by the ICC. It's attempting to destroy Palestinian people and erase Palestine, including by barring and obstructing humanitarian organization, thus also violating its obligations under the UN Charter and other instruments of international law. That is the context of the question before you. Mr. President, members of the court, UNICEF says Israel's onslaught has killed and injured 100 Palestinian children in Gaza every day since 18 March 2025. This is in addition to the more than 15,000 children Israel has killed since the onset of genocide, and the thousands who are still missing under tons of piling rubble of what was once their schools and their homes. Israel's genocidal campaign has turned Gaza into the home of the largest cohort of child amputees per capita in the world. Their limbs are amputated without proper medicine or care, sometimes without so much as a painkiller. Many don't survive, like baby Sham Mharib, whose arm was amputated following a strike on her home 18 days ago. Israel's genocidal campaign has also targeted UN and other humanitarian workers and organizations in Gaza, killing over 408 UN workers, among them almost 300 Unrwa staff. They have also killed 27 Palestinian Red Crescent Society paramedics in Gaza and 113 civil defense first responders. These killings are deliberate, not accidental. This was proven repeatedly, including in January 2024, when Israeli soldiers killed 6-year-old Hind Rajab and her relatives, then murdered the Palestine Red Crescent paramedic who received permission to rescue Hind while she was still alive. It was proven once more last March when Israeli soldiers ambushed and killed 14 paramedics and humanitarian heroes. The soldiers then buried the bodies in a shallow mass grave alongside with their crushed ambulances and emergencies in an attempt to hide their crime, while top Israeli officials lied to the world about the murders. This is the jarring equation prompting our appeals to the court and these proceedings. Israel is starving, killing, and displacing Palestinians, while also targeting and blocking humanitarian organizations trying to save their lives. These grave crimes aim to hasten the forcible transfer and destruction of Palestinian people in the immediate term. They will also ensure that our children will suffer irreparable damage and harm, placing an entire generation at grave risk. Already experts have concluded that life expectancy in Gaza has been slashed in half since the onset of the genocide. Mr. President, members of the court, this targeting of life in the Gaza Strip has been ongoing for years and in grave violation of Israel's legal obligation as an occupying power and as a member of the UN. Israel began engineering food deprivation in Gaza 19 years ago, making the majority of civilian population dependent on food aid to survive. A senior Israeli official then said, and I quote, "The idea is to put the Palestinians on diet, but not to make them die of hunger," end quote. Since October 2023, the blockade has progressively turned into a total siege. The Office of the High Commissioner of Human Rights said, "This siege is creating conditions that were incompatible with sustaining life or the continued existence of Palestinians in Gaza." These are the facts. Starvation is here. Humanitarian aid is being used as a weapon of war. All UN-supported bakeries in Gaza have been forced to shut their doors. 9 of every 10 Palestinians have no access to safe drinking water. Storage facilities of the UN and other international agencies are empty. More than 12,500 wounded Palestinians, including thousands of children, now require medical evacuation to have a chance at life. That is in addition to thousands of cancer and other patients dying slowly, dying in agony, and hundreds of thousands of children whose lives are in danger because Israel is denying entry of vaccines. Meanwhile, Israel continues to repeatedly, forcibly displace and starve the Palestinian population in Gaza. This UN-produced map illustrates how Israel has squeezed the population into a third of the Gaza Strip that it continues also to bomb. UNICEF, for example, has been forced to shut down 21 malnutrition clinics because of these repeated forced displacement orders. Israel has also waged a war on hospitals in Gaza, bombing them, laying siege to them, burning them, or leveling them to the ground. Israel has bombed and attacked all 36 hospitals in Gaza. The last hospital to be bombed was Gaza's Al-Ahli Baptist Hospital, an institution that has offered health to Palestinians since 1882. This hospital survived 2 world wars and many wars after, but Israel decommissioned it twice in the past 18 months. Israeli occupation forces have killed over 1,400 doctors, nurses, and other health workers. Some, like renowned surgeons Adnan al-Bursh and Iyad al-Rantisi, who were forcibly disappeared and tortured to death. Others, like director of Al-Awda Hospital, Dr. Ahmed Mhanna, was forcibly disappeared for over a year now, while director of Kamal Adwan Hospital, Hussam Abu Safiyi continues to be unlawfully detained. Only a handful of hospitals continue to bravely function, thanks to the heroic Palestinian doctors who remain and the brave international doctors volunteering to assist them despite the dangers and severe Israeli restrictions. To understand this, what this means in real bone-chilling terms, I ask you here this brief testimony of Dr. Muhammad Mustafa, an Australian doctor who was volunteering in Gaza last March.
We've worked throughout the entire night. We haven't stopped. The bombing has been non-stop. We've run out of ketamine. We've run out of propofol. We've run out of all painkillers. We can't sedate anyone. We can't give them any analgesia. When we intubate people, they wake up and they're choking because we have no sedation. There are 7 girls getting their legs amputated, no anesthesia. The bombing is still going on. The room is still shaking. I haven't slept. We went to bed at about 1 o'clock, and at 1:30 the bombing started. It's about 10 a.m. now. Just come back to my room. I'm lightheaded. I'm dizzy, and I mean, it was just mostly women and children, burnt head to toe, limbs missing, heads missing. You know, there's a video I put up on my story of me doing the chest drain. The gentleman that did the chest drain, and he died on the way to the CT scan. There's another video of 3 girls laying on a bed. That's his 3 girls, who are now orphaned. Their mother didn't even make it into the hospital. She was killed along with their other sister. I don't know what to tell you. This is, I was here in June, nothing to this intensity. This is unbelievable, and the bombing is still going on. The rooms are still shaking. The screams are everywhere. It's insane.
Mr. President, members of the court, the carnage and destruction extends to the West Bank, including East Jerusalem. There, Israel's killing of Palestinian civilians, including children, was record-breaking for 3 years in a row before 2023. Since the beginning of the year, Israel launched a military assault in the West Bank, unprecedented since 1967. Israeli occupation have demolished, razed, and burned the refugee camps in Jenin and Tulkarem, forcibly displacing more than 40,000 Palestinians. And Israel has announced that the displaced will not be allowed to return. The World Food Programme reports a near 100% increase in Palestinians in need of food aid in the West Bank, impeding the presence and activities of the UN and international organizations must be viewed in the context of erasure and forced displacement. Mr. President, members of the court, before I stand before you today on behalf of the persecuted people, fighting to survive, to live freely in our land. This is our inalienable and most fundamental right. It is not anyone to give or withhold, as this court has repeatedly affirmed. That's really the heart of why Palestine and over 40 other states are addressing the court today. It is not about the number of aid trucks Israel is or is not allowing into the occupied Palestinian territory, especially Gaza. It is not about Israel destroying it is about Israel destroying the fundamentals of life in Palestine, while it blocks UN and other humanitarians from providing life-saving aid to the population. It is about Israel unraveling fundamental principles of international law, including their obligations under the UN Charter. It is about Israel turning Palestine, in particularly Gaza, into a mass grave for Palestinians and those coming to their aid. Before I conclude, Mr. President, Allow me to describe the remainder of Palestine's presentation today. First, Mr. Paul Reichler will present Israel's legal obligations under international law and international humanitarian law. Next, Ms. Blinne Negroli will discuss Israel's violation of its legal obligations as a member of the United Nations. Then Professor R.D. Msis will address legal obligations specifically in relation to Unrwa. He will be followed by Professor Alain Pillay, who will discuss the legal consequences of Israel's violations of its obligations with respect to the provision of humanitarian aid to the Palestinian civilian population and the exercise of their right to self-determination. Finally, Ambassador Riyad Mansour will present the State of Palestine's closing remarks. I thank you for your kind attention and ask that you call Mr. Reichler to the podium.
I thank Ambassador Hijazi. I now give the floor to Mr. Paul Reichler. Sir, you have the floor.
Mr. President, members of the court, it is, as always, an honor for me to appear before you, and it is a privilege to speak on behalf of the State of Palestine. And on behalf of all of my fellow counsel here as part of the delegation, we are pleased to echo the congratulations that were conveyed to you by our agent on your election as president. I will address Israel's legal obligations under international humanitarian law concerning the provision of humanitarian assistance to the Palestinian civilian population, and then Israel's legal obligations under the rules of international law set out in the court's advisory opinion of 19 July 2024. I will conclude with some observations on Israel's legal obligations under overlapping rules of international humanitarian law and international criminal law. I begin with an update on the situation on the ground. On 1 March 2025, Israel announced that it would unilaterally end the 6-week ceasefire that had prevailed since mid-January, and that it would resume aerial bombardment and other armed attacks against Gaza. On the following day, 2 March, the office of the Prime Minister made this announcement. Prime Minister Benjamin Netanyahu has decided that as of this morning, the entry of all goods and supplies to the Gaza Strip will be halted. The Prime Minister's decision immediately cut off all humanitarian assistance to the Palestinian civilian population in Gaza. This was underscored by the head of Israel's civil administration for the occupied territory and Minister of Finance, Bezalel Smotrich, in another post on the same day. The decision we made last night to completely halt humanitarian aid to Gaza until Hamas is destroyed or completely surrenders and all our hostages are returned is an important step in the right direction. The threshold of the gates of hell. Now we need to open those gates as quickly and lethally as possible on the cruel enemy until absolute victory. Israel's Minister of Defense, Israel Katz, made clear that the cruel enemy was not just Hamas, but the entire civilian population of Gaza. He addressed this message specifically to them. Citizens of Gaza, this is your last warning. The Air Force attack against Hamas terrorists was only the first step. The rest will be significantly worse, and you will pay the price. Unless all the Israeli hostages are released and Hamas is expelled from Gaza, Israel will act with forces never before seen. The alternative is utter destruction and devastation. In keeping with these official Israeli statements, all humanitarian assistance intended for the civilian population of Gaza has been blocked by Israel since 2 March. No food, no water, no medicine, no fuel, no anything. For 57 days and still counting, Israel has prevented all goods and services of any kind from entering Gaza. On 9 March, Israel's energy minister, Eli Cohen, posted a picture of himself on the social media platform X, signing an order to cut off electricity to Gaza. The message accompanying the photo read, "I have now signed an order to cut off electricity to the Gaza Strip immediately. Enough with the talk. It's time for action." The impact of this action was to shut down the lone desalination plant in Gaza, depriving more than 600,000 Palestinians of their only access to water. Overall, the consequences for the Palestinian civilian population, especially the deprivation of urgently needed humanitarian assistance, have been as promised by Defense Minister Katz: utter destruction and devastation. According to the United Nations Undersecretary General for Humanitarian Affairs, who briefed the Security Council on 18 March, today I am distressed to report that in addition to the intense airstrikes that have resumed, since 2 March, Israeli authorities have cut off the entry of all life-saving supplies, food, medicines, fuel, cooking gas, for 2.1 million people. This total blockade of life-saving aid and basic commodities and commercial goods will have a disastrous impact on the people of Gaza, who remain dependent on a steady flow of assistance into the Strip. Blocking food, water, and medicine for people who need them is unconscionable. It also goes against international humanitarian law and the provisional orders of the International Court of Justice. Mr. President, members of the court, the Undersecretary General is plainly right. The facts on which his statement is based are not in dispute. As you have seen, they're admitted, proudly and loudly proclaimed by Israel's most senior government officials. Nor can there be any dispute about the applicable law. In its July 2024 advisory opinion, the court explained that international humanitarian law governs Israel's conduct in the OPT for as long as its occupation continues. Israel must thus comply with its obligations under the Fourth Geneva Convention, of which it is a state party, and additional Protocol 1, the relevant articles of which are part of customary international law. The indisputable evidence shows that Israel has flagrantly violated these obligations. They include, first, the obligation under Article 55 of the Fourth Geneva Convention to ensure, to the fullest extent of the means available, provision of, quote, the food and medical supplies of the population. Under this article, Israel has an affirmative duty to, quote, bring in the necessary foodstuffs, medical stores, and other articles if the resources of the occupied territory are inadequate, which is undeniably the case throughout the Gaza Strip. Article 69 of Additional Protocol 1 further requires Israel to ensure the provision of, quote, clothing, bedding, means of shelter, and other supplies essential to the survival of the civilian population of the occupied territory. Second, Israel has the obligation under Article 56 of the Convention to ensure and maintain, to the fullest extent of the means available to it, quote, the medical and hospital establishments and services, public health and hygiene in the occupied territory. Article 56 further provides, quote, medical personnel of all categories shall be allowed to carry out their duties. Israel has been blatantly violating these obligations, and not only since 2 March, it has been violating them for many years, most egregiously since October 2023. On 9 October 2023, Israel announced a complete siege of the Gaza Strip, cutting off essential resources and the movement of goods, including food, water, medicines, fuel, and electricity. All crossing points between Israel and the Gaza Strip were sealed. Israel's defense minister at the time, Yoav Gallant, described his government's strategy in these terms, quote, "A complete siege, no electricity, no water, no food, no fuel." The United Nations Independent International Commission of Inquiry found that this was precisely what Israel did. Quote, "Throughout the siege on Gaza, Israel has weaponized the withholding of life-sustaining necessities, specifically by cutting off supplies of water, food, electricity, fuel, and other essential supplies, including humanitarian assistance." On 6 December 2023, the Secretary General reported to the Security Council, "We are facing a severe risk of collapse of the humanitarian system. The situation is fast deteriorating into a catastrophe with potentially irreversible implications for Palestinians as a whole and for peace and security in the region." In response, the Security Council adopted Resolution 2720 on 22 December 2023, which recognized that the civilian population in the Gaza Strip must have access to sufficient quantities of assistance that they need, including enough food, water, sanitation, electricity, telecommunications, and medical services essential for their survival, and that the provision of humanitarian supplies in the Gaza Strip needs to be sufficient to alleviate the massive humanitarian needs of the Palestinian civilian population throughout the Gaza Strip. And the resolution reaffirmed the obligations of the parties to the conflict under international humanitarian law regarding the provision of humanitarian assistance. And it demanded that they allow, facilitate, and enable the immediate, safe, and unhindered delivery of humanitarian assistance at scale directly to the Palestinian civilian population throughout the Gaza Strip. Israel ignored the Security Council's demand, just as it disregarded subsequent Security Council resolutions 2728 and 2735, adopted in 2024, and 5 General Assembly emergency special session resolutions, which called on it again to allow and facilitate urgently needed humanitarian assistance at scale to the Palestinian civilian population in Gaza. In fact, Israel did the opposite of what was demanded to it. It continued to impede the provision of humanitarian goods and services indispensable to the survival of the Palestinian people, and it restricted humanitarian access by United Nations agencies, other states, and international humanitarian organizations. The court needs no reminding that Israel also disregarded its orders on provisional measures in the case brought by South Africa, which were issued on 26 January, 28 March, and 24 May 2024. Israel was required by the March order to take all necessary and effective measures to ensure, without delay, in full cooperation with the United Nations, the unhindered provision at scale by all concerned of urgently needed basic services and humanitarian assistance, including food, water, electricity, fuel, shelter, clothing, hygiene and sanitation requirements, as well as medical supplies and medical care to Palestinians throughout Gaza, including by increasing the capacity and number of land crossing points and maintaining them open for as long as necessary. Israel has ignored these obligations and refused to comply. By May 2024, the court recognized that, quote, the humanitarian situation is now to be characterized as disastrous, as indeed it was. And the situation grew even worse thereafter. On 28 October 2024, the Commissioner General of UNRWA made this report to the General Assembly. The situation in Gaza is beyond the diplomatic vocabulary of the General Assembly. After more than a year of the most intense bombardment of a civilian population since World War II, and the restriction of humanitarian aid far below minimum needs, the lives of Palestinians are shattered. The surviving population lives in the greatest indignity. In the north, the population is trapped, awaiting death by airstrikes or starvation. On 2 December 2024, the Secretary General reported to the Cairo Ministerial Conference, nothing justifies the collective punishment of the Palestinian people. Collective punishment is, of course, prohibited by Article 33 of the Fourth Geneva Convention. Secretary General continued, yet conditions for Palestinians in Gaza are appalling and apocalyptic. Malnutrition is rampant. Famine is imminent. Meanwhile, the health system has collapsed. What we are seeing may well amount to the gravest international crimes. In the face of the gigantic needs, humanitarian aid is outrageously being blocked. This flies in the face of the clear requirements under international humanitarian law to respect and to protect civilians and to ensure their essential needs are met. It defies numerous General Assembly and Security Council resolutions demanding a ceasefire and unhindered humanitarian access. And it ignores the International Court of Justice, which issued binding provisional orders that must be complied with. As appalling and apocalyptic as the situation was in December, it is even worse today. The Secretary General recognized this in a statement on 8 April. More than an entire month has passed without a drop of aid into Gaza. No food, no fuel, no medicine, no commercial supplies. As aid has dried up, the floodgates of horror have reopened. Gaza is a killing field, and civilians are in an endless death loop. The current path is a dead end, totally intolerable in the eyes of international law and history. And the risk of the occupied West Bank transforming into another Gaza makes it even worse. Mr. President, in these circumstances, there can be no doubt that Israel is violating its obligations under international humanitarian law, including its obligations under the Fourth Geneva Convention and customary international law, as reflected in Additional Protocol 1. In its written statement, Israel argues that its defense and security concerns justify its refusal to allow humanitarian assistance to the Palestinian civilian population, no matter how urgently this assistance is needed. This posture is as unlawful as it is inhumane. Under Article 59 of the Fourth Geneva Convention, as pointed out by the distinguished Undersecretary General for Legal Affairs earlier this morning, quote, if the whole or part of the population of an occupied territory is inadequately supplied, the occupying power shall agree to relief schemes on behalf of the said population and shall facilitate them by all the means at its disposal. The ICRC commentary on Article 59 explains, the obligation on the occupying power to accept such relief is unconditional in all cases where occupied territory is inadequately supplied. The occupying power is bound to accept relief supplies destined for the population. The convention not only lays down that the occupying power must agree to relief schemes on behalf of the population, but insists that it must facilitate them by all the means at its disposal. The occupation authorities must therefore cooperate wholeheartedly in the rapid and scrupulous execution of these schemes. Article 59 itself further provides, quote, all contracting parties shall permit the free passage of these consignments and shall guarantee their protection. The ICRC commentary explains that these obligations apply to any state that is enforcing a blockade, and it specifies that the consignments, quote, cannot, under any circumstances, be declared war contraband or be seized as such by those enforcing the blockade. Mr. President, the question posed by the General Assembly calls for the court to issue an opinion on Israel's legal obligations, and I quote, to ensure and facilitate the unhindered provision of urgently needed supplies essential to the supply of the Palestinian civilian population, as well as of basic services and humanitarian and development assistance. This question assumes that the relief consignments are humanitarian in nature. As such, international humanitarian law does not permit Israel to deprive the Palestinian civilian population of such assistance for any reason, including what it claims are its defense or security requirements. This is the conclusion reached by the ICRC itself. In relation to the current situation in Gaza, the ICRC has stated, the suspension of assistance now, including the cessation of power to the only water desalinization facility in Gaza, risks plunging Gaza further into an acute humanitarian emergency. Under international humanitarian law, Israel shall ensure that the basic needs of civilians under its control are met. The rapid and unimpeded passage of humanitarian assistance must also be allowed and facilitated. I now turn to Israel's legal obligations under the rules of international law applied by the court in its 2024 advisory opinion. I refer specifically to the court's determinations that Israel has no sovereignty and may not exercise sovereign powers in the occupied Palestinian territory, and that its presence there is unlawful, such that it must be terminated as rapidly as possible. I refer as well to the court's determination that Israel has an obligation to facilitate and not to impede the right of the Palestinian people to self-determination, including the right to a sovereign and independent state in the occupied Palestinian territory, and that Israel, by its presence in this territory, its annexations and its settlements, among other actions, has been systematically violating that obligation. The court further determined that third states and the United Nations are legally obligated not to accept the Israeli presence in the OPT as lawful or to contribute to its maintenance, and must work to bring it to an end, and that they have an erga omnes obligation to support the right of the Palestinian people to self-determination. These determinations by the court have at least three inevitable consequences for the present proceedings. First, because its presence in the OPT is unlawful and it lacks sovereign rights or powers within the territory, Israel has no legal authority to impede humanitarian goods and services from entering or circulating within the Gaza Strip or any other part of Palestinian territory. The decision to accept and receive humanitarian assistance, and from whom, is an exercise of sovereignty, which in the case of the Palestinian territory belongs exclusively to the Palestinian people, who are represented by the state of Palestine. Accordingly, in addition to its obligations to ensure and facilitate the provision of humanitarian assistance to the Palestinian civilian population under international humanitarian law, Israel bears an obligation under general international law not to override the sovereign will of the Palestinian people, expressed through their legitimate governmental representative, to receive in their own territory such urgently needed assistance and services as they may authorize from the United Nations, third states, and other trusted organizations. Second, Israel's prevention of humanitarian assistance from entering Gaza also violates its obligation, in the court's words, quote, not to impede the Palestinian people from exercising its right of self-determination. As the court explained, the right of self-determination includes the right to territorial integrity, the right to be protected against acts aimed at dispersing the population and undermining its integrity as a people, and the right of the people freely to determine its political status and to pursue its economic, social, and cultural development, all of which the court found were violated by Israel's prolonged occupation of Palestinian territory. By preventing humanitarian assistance from entering Palestinian territory, Israel further violates each of these components of the right of self-determination. In particular, Israel's denial of food, water, and other essentials of life to the Palestinian civilian population inevitably impedes their economic, social, and cultural development. And it is intended, as Israeli officials themselves proclaim, to displace and disperse the Palestinian population, especially in Gaza, but increasingly in the West Bank as well, which undermines their integrity as a people. Mr. President, I see that the clock is approaching 11:30. I have somewhere between 5 and 8 more minutes of my speech remaining. If you allow me to continue, I would be happy to do so. If you prefer to take the coffee break, obviously that's fine with us. We're entirely in your hands.
I think we can have coffee after you finish your remarks.
Thank you very much, Mr. President. Israel's prevention of humanitarian assistance also violates the territorial integrity of Palestine, another essential component of self-determination. As shown on this map, in the southwest Gaza borders Egypt. The main border crossing is at Rafah, which is where most humanitarian assistance, before it was blocked by Israel, entered Gaza. Israel enforces its blockade on goods entering here from within Palestinian territory, thus violating its territorial integrity. The situation is similar in the east, where Israeli forces stationed in the West Bank, including East Jerusalem, prevent or restrict the entry of humanitarian assistance from Jordan via the King Hussein al-Karama bridge crossing, again, in violation of Palestinian territorial integrity. As the Secretary General observed, the humanitarian situation in the West Bank, including East Jerusalem, is also grave due to Israel's prevention or restriction of humanitarian assistance to the millions of Palestinians who live there. While Israel has not announced a formal cutoff of humanitarian assistance to the West Bank, as it has to Gaza, it has imposed major obstacles to the delivery of such assistance, including the arbitrary withdrawal or denial of operating permits for humanitarian organizations. According to the Commissioner General of UNRWA, while a number of international NGOs have already been silenced, there is now a larger concerted effort in Israel to undermine or restrict through legislative measures the operations of international organizations and NGOs. In occupied East Jerusalem, the agency is facing increased pressure from the municipality to vacate premises and end service provision. International staff have been effectively expelled from the occupied West Bank due to the lack of valid visas. The vast majority of the states and international organizations participating in these proceedings agree that Israel's shutdown of relief operations and denial of urgently needed humanitarian assistance to the Palestinian civilian population violate its duty not to impede the Palestinian people from exercising their right of self-determination. According to the Netherlands, for example, in a situation of extreme dependence on relief operations, the occupying power's unilateral decision to terminate its agreement and cooperation with a third party responsible for the bulk of the humanitarian assistance directly and severely affects a people as a whole, frustrating its economic, social, and cultural development. This has severe negative consequences on the ability of the people concerned to exercise its right of self-determination. The written statement of the Secretary General explains, quote, "The obligation of Israel to respect the right of self-determination of the Palestinian people has another important aspect: to respect the decision of the Palestinian people on the manner in which the dependence of the West Bank, including East Jerusalem and Gaza, on Israel for the provision of basic goods and services should be reduced. Therefore, in instances where the representative of the Palestinian people decided to receive basic goods and services from United Nations entities in order to fully enjoy its right of self-determination, Israel is bound to respect that decision." The third consequence of the 2024 advisory opinion is that Israel's prevention of humanitarian assistance from other states and the United Nations violates its duty not to prevent them from fulfilling what the court found to be their erga omnes obligations to support and facilitate the exercise of self-determination by the Palestinian people. Many states and international organizations emphasize this point. The African Union, for example, explains that as a member state of the international community, Israel must cooperate with third states to ensure the effective enjoyment by the Palestinian people of their right to self-determination. It must therefore grant all facilities at its disposal for the provisions by third states of the support necessary for the latter to be able to self-determine. Mr. President, I come now to the final part of my presentation, and the briefest, on Israel's legal obligations under parallel rules of international humanitarian law and international criminal law, particularly those which prohibit starvation of the civilian population as a method of warfare. This practice, which Israel, by admission of its senior government officials, deliberately employs against the Palestinian civilian population in Gaza, is unlawful under both Article 54.1 of Additional Protocol 1, which expressly prohibits it, and the Rome Statute, which provides in Article 8.2b that, quote, "intentionally using starvation of civilians as a method of warfare by depriving them of objects indispensable to their survival, including willfully impeding relief supplies, is a war crime." In fact, starvation of civilians as a method of warfare has been recognized as a war crime, at least since the judgment of the Nuremberg Tribunal in 1946. 8 decades later, it is Israel that is deliberately starving more than 2 million Palestinian civilians in Gaza to achieve its purported war ends by cutting off all supplies of food, water,